Okay. All right, let me try for the third time. Today is April 12th, 2022. It's 8:30 in the morning. This is a civil bench trial calendar. My name is Brad Gardner. I'll be the magistrate court judge presiding over this matter here today. When I call your case name, I need you to make an announcement. And that announcement is either ready for trial or you would like the opportunity to discuss your matter with the opposing party. Miss Maxine, I'm gonna put you on mute because you're making too much noise, man.
Okay. What's the fucking paper?
Okay, position number one is Yoselin, it says Tatis versus Title Max of Georgia. Is Miss Tatiz present? Is anyone present from Title Max of Georgia? Okay.
Absent, Judge.
That'll be dismissed for warrant of prosecution. Position number two is Finley Roofing and Construction versus Cruz Edith.
Present, Your Honor, Max Perwich on behalf of plaintiff. I'm trying to get my camera here to work and I've called our IT department. But I am present here with Joseph Lanham, who's also in the call today, working with IT to get the camera to work. I don't believe I see Miss Cruz in here yet.
I do not see her.
And Your Honor,
apologies, Your Honor. We tried to mediate this case, so we're ready to proceed to trial.
I see that there is a mediation report filed on March 1st.
Correct. And I think too, Your Honor, that this case is ripe to just be decided as a default judgment. The plaintiff, or the defendant rather, did not file an answer. And I filed a certification this past Friday referring to the court docket on that. She never filed an answer. We tried to mediate it, came to an impasse, but we believe it can be disposed of via default judgment.
Okay. You're gonna have to get your camera working, Mr. Perwich.
Will do, Your Honor. I'm working with IT right now.
Okay, position three is Irvin Topper versus Jeffrey Nix.
Your Honor, Jeffrey Nix is present.
Okay.
Your Honor.
Is Mr. Topper present?
Yes, Mr. Nix.
Okay, so I saw that there was a mediation report filed on March 3rd in that case. So I assume you were not able to reach an agreement, Mr. Nix?
That's correct, Your Honor.
Okay, and I did not see a counterclaim filed. If Mr. Topper doesn't show up, this will be dismissed.
I did not file a counterclaim.
Okay. Position number four is Lang Enterprises versus Peggy Turner.
Your Honor, Mr.
Zach Proctor for the plaintiff, Your Honor.
Okay.
She's coming forward, Your Honor.
Okay.
Dana Tucker Davis, Your Honor, for Peggy Turner. I believe she and her witness are in the courtroom. I am trying to get to a better connection place.
Okay.
The parties went to mediate. They did the informal mediation and formal mediation, and neither one worked.
I see that there is a mediation report filed on March 1st in that case.
I anticipated to be about 30-minute hearing.
Okay. And there is an answer and a counterclaim file.
Correct, Your Honor.
Position five is Brookwood Loans of Georgia versus Barbara Talbert.
Barbara is here, Your Honor.
Good morning, Your Honor. My name is Kelly James and I'm the agent for plaintiff.
Okay. And I see that there is a mediation report filed on February 28th. And I'm assuming you were not able to reach an agreement.
We weren't.
Okay. And Miss Talbert.
Yes, I'm here.
Okay. Position number 6 is Capital One Bank versus, is it Cynthia Eduardo? Or
Yes,
Edward?
Edward.
Edward, okay. And,
Good morning, Your Honor. Louis Feingold for Capital One.
okay. I did not see a mediation, but this looks like it's a default.
No, there was an answer admitting and the defendant, and I'm afraid, would you pronounce your name again? I'm sorry.
Cynthia,
Cynthia?
Michelle Edward.
Okay, and Cynthia has been making payments, but we just don't have a signed consent agreement to file with the court yet. Is that
So-
right, Cynthia?
No, that's not right. You asked me for the paper. You said to sign it, and when I signed it, I wasn't supposed to date it. And I called you guys. You said it was okay, and I sent the paperwork over there. So I don't know. I have been complying. We already made an agreement, and I've been making payments. I never miss my payments, so I don't even know what I'm doing here.
Would you check on that, Mr. Feingold?
Well, I did before, and we do not have a signed consent agreement. And basically, if it's okay with the court and Cynthia, after the call of the calendar, if we could go to a breakout room, I can get all the details and explain everything to Cynthia and send a consent agreement. And once I get that back, file it with the court.
Okay. When I look,
I'm sorry.
hold on, ma'am. When I looked this up, it said that there was a motion for default filed on March 11th of this year.
All right, let me check on that.
I'll place you in a breakout room at the end of the calendar so you and Miss Edward can speak, because it just seems like there's a miscommunication somewhere.
Yeah, and I'm looking and I don't see the default, but there was an answer filed and payments are being made. So hopefully, we can work it out.
Well, it seems like it's been worked out. It just looks
Right.
like there's a Miss Edwards.
Oh, I'm sorry. I keep forgetting I'm in court. I'm so sorry.
Yes, ma'am, you are in court, and this isn't Judge Judy. Okay.
That's right. Okay.
Ma'am, listen. I've heard you. It appears to be a miscommunication somewhere.
Mhm.
So seems like there has to be conversation to fix the miscommunication. Okay?
Okay.
Do you believe that you can drop it down a little bit,
Mm-hmm.
act like you're in court,
Mm-hmm.
and speak with Mr. Feingold for the purpose of resolving whatever miscommunication has taken place?
Okay.
Thank you, ma'am.
You're welcome.
Position number 7 is Wynn versus Van, and my understanding is that that's going to be continued by the request of the parties. So this will be continued to another date. Position number 8, Maxine Kelly versus Kevin, is it Milaga? Milaga.
Yes, sir.
Miss Kelly. I'm gonna need you to unmute yourself, ma'am. Ma'am, if you can't work your camera situation out, your case is going to be dismissed when it's called. Okay. Position number 9 is Discover Bank versus Nicholas King.
Good morning, Judge. That is my other case.
Okay. And it looks like this was transferred from another county.
I am not sure, Judge. I'm covering this morning, and this is the first I've heard of that.
Okay. That's the notes that I have.
Okay.
And is anyone here on behalf of Mr. King? All right.
Judge, at the appropriate time, I'll move to strike his answer and enter default.
Yes, sir. Position 10 is Bank of America versus Lawrence Anderson.
Louis Feingold for Bank of America. And I have good news on this one, Your Honor.
Okay.
Mr. Anderson has settled this case.
Okay.
And we have, well, I think we've tried to e-file the dismissal with prejudice. And I don't know that that's actually been done yet. So we have mailed the original dismissal to the court.
Okay.
So one way or the other, we're dismissing this case.
Okay. And my understanding from the clerk's office is that when a case is dismissed at the call of the calendar, they want me to do an order of dismissal. So could you email that to Miss Mary Moultrie?
Sure.
Okay.
Okay, and would that just be the magistrate court hearings email?
No, you're going to mail it to, I'm going to put it in the chat for you, Mr. Fargo.
Oh, okay. Perfect. Thank you, ma'am.
So I see there's a AT&T Motivate that came up. Is that you, Mr. Purwich?
Sorry, Your Honor, could you repeat that?
Oh, I'm sorry. I see you now, Mr. Purwich. I'm sorry.
I'm glad.
The person that has AT&T Motivate 2 looks like it's the audio is trying to connect. I'm going to need you to connect your audio and come on. Okay. Ms. Edward and Mr. Feingold, I'm going to assign you to breakout room 1.
Okay.
All right. Thank you, sir.
Thank you both. All right, the two of you should be able to click on the link. There should be a link that comes up, Ms. Edwards, so that you can click on it and enter that room. Mr. Feingold, you should be able to enter the room also.
Yes, sir. Thank you.
Okay, now I see that we have several trials that are set Did we ever get an announcement from Mr. Topper?
No.
Okay. So I'm going to dismiss that case for warrant of prosecution. Mr. Nix, you are free to go.
Do you have any questions for him?
No, will I receive some notice?
He has a question for you, Judge.
Okay.
He's coming forward, Mr. Nix.
Will I receive some notification of this, Your Honor?
Yes, it should be an order prepared in about 10 days. It'll get filed and it should get mailed to you at the address that you've given to the clerk's office.
Thank you very much.
Okay, have a good day, sir.
Good one, sir.
Thank you, Mr.
You're welcome, Mr. Nix. Have a good day, sir. Thanks for coming in.
Ms. Davis and Mr. Proctor. Ms.
Yes,
Davis,
Judge. Can we sound for my witnesses? Make sure that they're here.
who are your witnesses?
Lawrence Nelson and or Corey Jackson.
And they were coming to the courthouse?
I believe they were supposed to be on Zoom, Judge.
I do not see them. Was that you, Miss Kelly?
Your Honor, if his witnesses aren't present, then I would ask the court to entertain a motion to dismiss.
Mr. Proctor, do you believe you can proceed without your witnesses?
No, Judge, I don't believe I can.
Okay. Well, I'm going to grant Ms. Davis's motion to dismiss.
I
Yeah, Your
understand,
Honor.
Judge.
Okay.
What? Only thing, Your Honor, we filed a counterclaim as well.
Okay. Do you have your witness here?
My witnesses are physically in the courtroom. One is outside and the defendant is physically in the courtroom. I think she has on that mask and a pink shirt, Peggy Turner.
Yes, Your Honor. If it pleases the court, Ms. Turner had to excuse herself. She had to use the restroom. She will return back shortly.
Okay. Ms. Davis and Mr. Proctor, do you believe, based upon the fact that your witnesses are not there, that you two may need to have a discussion in the breakout room about how
No.
best to proceed?
No.
Ms. Davis,
I
is there
said
a
no.
reason? I heard you, ma'am. I'm about
Oh, I'm
to
sorry. I
ask
thought
you.
you didn't. I thought you didn't hear me. I told you I had connection problems.
You
earlier.
said no 3 times, and I was trying to speak to you, and you kept saying no. I said no. I said no. Ma'am, is there a reason that you believe you cannot reach an agreement as to your counterclaim without even asking?
Your Honor, the parties have tried to.
Ma'am, I heard that. Y'all went to mediation, didn't work out. Okay. His witnesses are not here, so his part of the case is going to be dismissed, which may put him in a different position as it relates to working the case out. Or it may not. Why not just try?
Your Honor, I think we've satisfied the requirements for mediation and informal mediation prior to a trial in magistrate court.
Okay. Well, I'm gonna call your case at the end. All right.
Okay.
Position number 5, Brookwood Loans of Georgia versus Barbara Talbert. Is this case ready to proceed?
I am, Your Honor. I'm
I
not
am.
sure about Ms. Talbert, but I am.
Okay. For the purpose of the record, I'm calling case number 2020 CM 11642, Brookwood Loans of Georgia versus Barbara Talbert. Case was filed on August 3rd of 2020. Looks like an answer was filed on September 15th of 2020. Ms. James, this is your time.
Yes, sir. So Ms. Talbert took out a loan with our company on June the 4th of 2014. We lent her $3,250. The original terms of the contract were 36 payments of $194.31. She made 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 payments out of the 36. We have permanently stopped the interest as of January the 26th of 2016, which is approximately 90 days after the last payment was made on the account. We are asking for a total of $3,638.53. That breaks down into $2,765.09 in principal, $773.44 in interest, and $100 in court costs. And we are not seeking whatever interest is allowed on the judgment because we have permanently stopped the interest from further accruing.
Okay. Ms. Talbert, would you raise your right hand for me, please, ma'am? Do you swear affirming the statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes, sir.
Do you have any questions of Ms. James?
No, it's just the bank couldn't provide me with information prior to 2015. So I couldn't prove that they removed money after they gave me money. My complaint was that they only gave me $1,200, but I need the information from the bank between the for 2014 and that the bank couldn't go no further back than 2015. So I can't prove that because I can't get the information from the bank. I've been with the bank since 2009 till 2018 or something like that. But I couldn't get that information, sir. So
you agree that there is a debt owed?
yes, sir. Actually, I felt like I had paid it because from what they actually gave me and what they took out of my account, I remember it coming up to $1,200. But the bank couldn't help me to prove that. So, I mean,
I've got a copy of a signed ACH agreement, which was signed by the defendant, and that legally only allows us to withdraw the $194.31 monthly beginning on 7/11 of 2014 until either the payments are physically stopped or the bank account is closed or something with the bank. But we legally were not allowed to withdraw more than the $194.31. So we would not have deposited $3,250 and then immediately snatched whatever the difference you say is back for out of your account. That we can't do that legally.
So let me ask a question. It sounds like Ms. Talbert is saying that she didn't get the documentation that she felt was necessary for her to agree to this. That I know this went to mediation. I would presume that that's the purpose of mediation, is to figure this stuff out. Meaning, if you ask in mediation, hey, I just need this documentation, that I would presume that they would then get the documentation and it's either there or it's not.
is that question posed to me, Judge?
Yes, ma'am.
Okay, I went to the bank and got what they were willing to give me, sir. And I had to pay for that.
No.
The bank that I was dealing with is out of business.
I understand. I understand.
Okay.
For all intents and purposes, when account holders want to close out and pay off their account in full, per the ACH contract, we legally, again, can't do the payoff amount. We can only do the monthly minimum payment per the contract. So when people want to pay off their loans in full, they have to either mail a check, a money order, or call in a debit card payment over the phone. And none of those happened in this case. So, I mean, I'm really not certain why the misunderstanding is there in regards to the total amount borrowed.
Did you participate in the mediation?
Yes.
Were you asked to provide documentation?
No.
Judge Feingold, can you help me? I don't understand.
What kind of documentation? Proof that she took out the loan? Because I provided a contract, I provided.
No. I'm just asking. So what I hear you're saying is that the information that Ms. Talbert provided today was not provided when you went through mediation. I mean, the question wasn't asked when you went through mediation.
Correct.
Ms. Talbert?
Oh, please forgive me, but what was the question, sir?
You testified here today that you didn't get the documentation that you needed to understand how they came to the amount that they were requesting. And you said that, well, you think it's 1,200, and then, well, maybe I don't even think it's that. So the purpose of a trial for a judge, listen to me.
Yes, sir.
I have to listen to both sides and I have to make a decision. I've been given numbers that appear to prove Brookwood Loans' side of the case.
Okay.
So I'm going to find for Brookwood Loans. Could you repeat those numbers? You said you're asking for $2,700.09
Yes.
plus.
The principal is $2,765.09. The interest requested is $773.44. And the fees are $100, and that was a court.
Hold on. You're going too fast. I'm trying to write this stuff down.
I'm
All
sorry.
right. $2,765.09. Okay.
Yes.
Interest is what?
$773.44.
Okay.
And then court cost is $100 even.
Okay. So I found for Brookwood Loans, there will be an order entered in about 10 days reflecting $2,765.09, $773.44, correct? And $100 in court costs.
Yes,
Okay.
sir.
All right, so the parties in this case can be excused.
Thank you. Have a great day.
Thank you, Your Honor.
You're welcome. Mr. Feingold, were you and Ms. Edwards able to reach an agreement, an understanding?
Yes, Your Honor.
Okay,
And
so we got it all worked out.
yes, sir. And thank you for the opportunity to clarify the misunderstanding. And Ms. Cynthia and I have worked it out, and I'm going to mail her an agreement. and it's going to have a self-addressed stamped envelope in the envelope. So she can just put it in the envelope and mail it back to us, and then I'll sign it and file it with the court.
Okay. And Ms. Edwards, is that your understanding of the agreement?
Yes.
And Ms. Edwards, you see what happens when you can just talk to people?
Yes.
Thank you, ma'am. You have one more case, Mr. Feingold, is that correct?
Well, that was the one
Oh, it was
dismissal.
right.
And I'm going to email the dismissal to Ms. Moultrie.
Okay, thank you. The parties in this case can be excused.
Good
All
to
right.
see you, Judge. Thank you.
Okay. Let's see. It's Kelly. I'm getting close. I'm going to call position 9. We're Mr. Proctor. I do not believe
Yes, Your
Mr.
Honor.
King. I do not believe Mr. King ever arrived.
I believe that's correct, Your Honor. So I'll move to strike his answer and enter a default. If I could get Ms. Moultrie's email address, I will send in a proposed order.
Yes, sir. It's in the chat. It's in the chat.
Yeah.
Oh, okay, I'll get it.
Okay.
Thank you, Your Honor.
Okay, now we're back to you, Ms. Davis and Mr. Proctor. Mr. Lanham, sir, are you a witness here?
Your Honor, Mr. Lanham is with Findlay Roofing in the Edith Cruz case. He would be my witness.
Okay. Okay.
Your Honor, on the Lang Enterprises versus Peggy Turner case, on our counterclaim, because if you're granting our motion to dismiss, then my question is, if we voluntarily dismiss that without prejudice to file later, I heard you earlier say that if it happened at the trial, you had to enter an order of dismissal, and I didn't want that.
Okay. I will.
And I'm perfectly happy with dismissing both without prejudice.
Okay. Do this for me, Ms. Davis. Would you send in a proposed order of dismissal without prejudice? I'll grant your request, and I will sign that.
So I guess my only question about the dismissal of their case without prejudice, they're not here to prosecute, so I don't know if that's the same. That's a different kind of dismissal than we're doing a voluntary dismissal.
Oh, you're correct. Lang Enterprises will be dismissed with prejudice. Their part, the counterclaim, I'll allow that to be dismissed without prejudice, so you can refile if you so desire.
Okay.
Excuse me.
Yeah, my witnesses are physically in the courtroom. So even though I'm parked outside the courthouse, I just want to make sure that they know that they can leave, and then I'll call them.
Right, that's Mr. Hutchison. We're bringing them up.
Yes, Your Honor. Here is Miss Peggy Hunter, Your Honor. I'm going to go get the witness. Turner. I'm sorry, Miss Peggy Turner, and I'm about to go get the witness from outside the courtroom.
Good morning, Your Honor, and Miss Davis.
Good morning, Ms. Turner. Did you hear your lawyer's announcement?
Yes.
And she said that she's outside the courthouse. And I'm assuming at some point in time, she's gonna talk to you and just let you know what to expect moving forward.
Okay, thank you.
I'm sorry,
If you go outside the building, if you go outside the building, Ms. Turner, I'm gonna call y'all and tell y'all where I am, and you can come to meet and we can talk.
Okay, and I have
Here's the witness, Your Honor, Miss.
Ms. Smalls.
Okay, Ms. Small, there has been an agreement reached. Ms. Turner will be able to tell you. Ms. Davis, the lawyer, she's outside of the courthouse, and I believe that she's gonna speak to you all and fill you in even more. Okay.
Okay.
You both are free to leave, and Ms. Davis, you're free to go, but just send that in so we can get it signed. Okay.
I will, and I have Ms. Moultrie's email on Clayton County.
Okay, and just so that everybody understands, the plaintiff's case is going to be dismissed with prejudice because they did not appear at the call of the count of the case. The counterclaim is going to be dismissed without prejudice, which means that it could be refiled at some point. But I believe Ms. Davis is going to explain that all to you. Okay.
Yes, thank you, Your Honor.
Okay, you're welcome.
And Judge, just to be sure, the record's reflecting that my witnesses didn't show up, but I was here.
Yes, sir.
I just don't want anybody coming after me saying I didn't show up. So
No,
No.
and I will make sure I cover you on that. I've been on the other
thank you,
side.
Ms. Davis. I appreciate that.
Okay.
Excuse me, Judge, if it please the court, Ms. Davis, we're on the second floor. When you go to the double doors, make a right, we're by 204, room 204.
Okay, thank you.
Yeah, I think she's gonna stay outside.
I'm stay out. Yeah.
Oh, outside, oh, okay, I got you. Okay, got you.
Thank you.
Okay, so the parties in this case can be excused.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
You're welcome. Okay, Mr. Purwich.
Yes, Your Honor.
Y'all have a great day. Take your time now.
All right, so for the record, I am calling the case of 2021 CM 18991 Finley Roofing and Construction versus Cruz Edith. Miss Edith is not present. I have a notation that this was a default. Is that correct, Mr. Purwich?
Yes, Your Honor, it would be in default. This past Friday, I went ahead, rechecked the court's docket. No answer has been filed, and we filed a Rule 15 certification to establish that, which attached a copy of the docket I'm referring to. And I could also pull up my screen to show you the docket as well if needed.
No, it's not needed. So you have your witness here. Do you need your witness to establish damages?
I don't believe so here, Your Honor. Our claims are really for a breach of contract, and we submitted before the hearing an updated April 2022 invoice showing that the amount due currently with 1.5% monthly interest assessed each month has accrued to $13,253.09. For context, $0 had previously been paid on this account.
Okay.
I also submitted my attorney fees bills unredacted. The contract that we attached as Exhibit A to our complaint, and I can pull it up if needed, authorizes Findley, if it has to go to collections, that the party responsible to pay will have to pay reasonable attorney fees and costs. The amount of our fees as of yesterday, and this is after, demand letter, complaints, 2 mediations. The first one failed because she couldn't connect, so we had to sit around. And the second one just failed outright. Total amount of fees as of yesterday, I can state in my place, was $3,245. So we would limit our pursuit of recovery, obviously, to the magistrate court's jurisdictional limit of $15,000 plus court costs.
Of $100, or is there?
Yes, $100.
Okay.
And I submitted a proposed order to the court, it had directed on the notice to the Clayton County, Georgia.gov magistrate link. I can resend that to Ms. Moultrie. That basically it says, final judgment in the amount of $15,000. I might have to add plus the $100 of court costs.
Okay. So the rule of the court would be that there is a total money judgment of $15,000 plus $100 court costs. If you send that over to Ms. Moultrie, I will sign it. And Mr. Lanham, I will let your lawyer explain what just took place, but do you have any questions of me?
I do not, Your Honor. I appreciate that.
Okay. All right. So parties in this case can be excused.
Thank you, Your Honor.
You're welcome. All right. You know what? All right, the final case that I have on my calendar is 2021 CM 17785 Maxine Kelly versus Kevin Milaga. I'm sorry, sir.
Yes, sir. That's it. Milaga.
Okay. Now, Miss Kelly, you have been unable to turn your camera on. That's going to leave you with no choice but to dismiss your case.
Yeah, I understand, Your Honor.
Okay. So, and just, I'm gonna have to dismiss it. So this will be dismissed for warrant of prosecution. Is there any questions?
I don't have any. Thank you.
Okay. All right. Well, that completes this calendar. You can be excused, Mr. Milaga and Ms. Kelly.
Thank you.
All right. Thank you, Your Honor.
I'm sorry.
All right. Thank you.
Okay.
Judge Gardner, do we have a 1:30 calendar?
We do have a 1:30 calendar with 4 people on it.
Okay.
And hopefully it'll move fast because I have to get my car fixed.
Yes, sir.
AT&T Motivate 2. I don't know who that is. It never came on.
It didn't, Judge.
Okay. Well, I'll see everybody at 1:30.
Judge, have some breakfast now. Make sure you eat now.
Bye, Judge. Thank you.
Goodbye. I'm going to do that now. Okay.